discuss history on our museum segment, which is up next.
I was nominated by the President to serve in that docket. And following that nomination, Mr. Speaker, it is now my departure from this august house is imminent.
In accordance with the Constitution, this afternoon, I'll hand over my resignation letter.
I'm truly grateful to the people of Kandara constituency for finding it fit to give me 3 terms, which then the 3rd term, Mr. Speaker, I may have to surrender or I will be surrendering.
We cannot judge as members of parliament because we already judge out there. And we have to give people opportunity, Mr. Speaker, to be heard at any level.
Mr. Speaker, I had some of our colleagues here who are accusing some of the nominees, especially Benina. And some of them even, they don't have the qualification the nominee has.
She has not been charged in any court in this country on any issue.
Apart from a few individuals who are not even more than 8, the rest are incompetent, unqualified, have integrity issues, are people who cannot deliver this country from where it is to the next level that we want the country to move in.
I beg to reply and ask all members to, in a very bipartisan manner, support all these nominees to allow His Excellency the President to go ahead, swear them in, and form government.
Tumesema hizo barabara zote tutazitengeneza kwa sababu barabara ni ya muhimu. Inawasaidia kupeleka mazao yenu sokoni. Inatusaidia kwa mambo ya usafiri. Inatusaidia kujenga uchumi. Na hiyo ndio kazi ambayo tunataka tuondoe umaskini, tupeleke taifa letu la Kenya mbele.
Na ningependa kukuambia your visit here in Mukurweini has very serious historical significance. Kwa sababu hakuna rais mwingine ambaye amekalia mamlaka tangu wakati tulipata uhuru alikuja hapa kufanya maendeleo.
Kwamba hao watu wananyanyasa wakulima ya kahawa, ya chai, ya maziwa, rais amenisimamia hapo nyuma ningangane na hiyo watu. Tumekubaliana na Waziri Alice. Tunajenga dams ingine 100 Kenya ya kusukuma maji kila sehemu ya Kenya.
Nakushukuru sana kwa sababu sasa tukiunganisha maji ya kulima, ile fertilizer subsidies, umasikini na jaa hapa umeisha kabisa. Negwado ito.
Excellency, we will not let you down. Tuko na programs ambaye they cannot wait to be rolled out. Upande yangu wa maji, niko na all these dams that are called the colonial dams. His Excellency has asked for an audit as we are planning to roll out the bigger work of the mega dams.
Najaribu kusema watu waende kufungua masava na nini. Kwani mwaka mmoja imepita na ujui kwamba rais wa Kenya ni William Samoei Ruto? Si hiyo ni wazimu? Si unafiki kabisa? Si ni ukora?
Wakileta zingine tutawasikiza kwa heshima, lakini mambo ya cost of living, Mheshimiwa Rais, hiyo umewaambia na tunawaambia ndio kazi wananchi wa Kenya walikuajiri uwafanyie.
Wakati mzee amekubali dialogue, rais anaanza kupiga kifua, kutusi Raila. Umeona jana akipiga kifua akitusi Raila. Na yeye ndiye amesema nataka dialogue. Raila has nothing to lose. In fact, mahali imefika mimi naambia Raila, kaa ngumu bwana. Wacha mwanaume ndiye akupatie heshima. Kaa ngumu utingize yeye sasa mpaka kwa nafsi.
Hii watu nitawakalia ngumu. Mimi siwezi kukubali tena. Imetosha. Ama namna gani jameni? Tunaelewana?
Politically, I want to say the Kenya Kwanza does not have a goodwill or does not want this country to move forward. Even the talks are just means of pushing Kenyans to the corner. From the day one, they didn't mean well for this country. That is my personal observation.
Unajua wamezoea tabia mbaya. Walilete kisirani kwa Moi wakapata kitu. Wakalete kisirani kwa Kibaki wakalete pata nusu mkate. Wakakuja wakalete kisirani kwa Uhuru wakapata handshake. Hapa hakuna handshake, hakuna nusu mkate, hakuna chochote.
We are ready to engage with you on the basis of mutual respect, not with threats, not with blackmail. You must not blackmail us, that if we don't do what you want, that you will go back to the streets. And we want to tell you, even those streets, if you want to go back, nendeni, mutapambana na wenye munapatana nao huko. We have agreed on Wednesday, 11:30 a.m., we shall meet, but we want to meet in a public place like Bomas of Kenya, and we want cameras in that meeting, so that you tell us, and the people of Kenya want to hear what you are coming to transact in that room.
All right, tomorrow is a big day, and we've had 11:30, they will be meeting. And so everyone is not really rowing back as far as their stance is concerned. Azimio has been raising concerns regarding also ICC and the touring of Karim Khan in the country. And the latest development right now is that Karim Khan, who is a prosecutor of ICC, has recused himself from anything or any case where Kenya is involved. And we saw earlier also the cabinet vetting that was going in-house as well, and where we had some of the faces who are cabinet secretaries, then there were members of parliament in the house. Right now, just to give you the latest development, is that President Ruto also is currently chairing a cabinet meeting at Sagana State Lodge. And of course, he will later commission the new KCC plant in Kiganjo. That is the letters that we have this morning. But let's buckle down to some discussion now in light of the soapbox, and we'll also go back to our museum and dig out some of those clips that we had for you as well to just refresh your memory. But Dan Mazo, let's just begin with you on that particular note. First of all, you had raised hesitation with Karim Khan being in the country and, of course, holding court with President William Ruto. And you're saying he cannot actually be doing this because of the optics. We have a case in regard to the Azimio protest and Mandamano where people had died, and yet Karim Khan is here. Now that he has recused himself, is it a sort of a relief to you?
Well, recusal is expected of him because he's been the lawyer for William Samoei Ruto in the ICC before, and that creates what we call conflict of interest. So it is common for a lawyer to recuse himself, but when you recuse yourself when you are the prosecutor, it means a Kenyan case. Then if any, it means a Kenyan case must have a new prosecutor or another person appointed as prosecutor in this matter, should the complaint in Kenya against what has happened so far. And I really want to say there are high thresholds. And I'm happy Honorable Mugatana is a lawyer, and a good one. There's a high threshold of a case you can really make against some of the actions which has taken place in the past or likely to happen in future. Demonstrations, if you don't interfere with them and you don't kill anybody, they will go on very peacefully. So I want to say that Azimio has been conducting peaceful demonstrations, but unfortunately they are disrupted by the government through the police, and deaths, of course. And in fact, for all the people who have died so far, we need case by case, to have inquest, each single case, as to how that person got injured and died or was killed, by who, where. And Kenyans who have witnessed these things need to come forth and give statements. And we have an inquiry. Those inquiries are conducted by magistrates in that particular locality, like in Makueni, it was in Emali. There was another incident in Makueni town, and the incidences in Mulolongo can be conducted by the courts near Mulolongo. There are courts in Athi River. So that the magistrate prepares a documentary as to how this single person died. And whoever is being suspected, they can either be charged with murder or manslaughter. Because what has happened is that has happened. And what every single policeman should know who is carrying a weapon. If you use the gun and somebody's life is lost, there are only two ways. You are either guilty of manslaughter, and in the case of Kisumu, where after 2 days, certain policemen went into homes of suspects and thrashed them out and then killed them. It means they had enough time to premeditate murder. And for that, I believe those ones should be charged with murder. Not a single police officer whose life has been lost in his hands should go unprosecuted in this particular matter. And should the matter escalate, because I don't see much from the talks. We are very clear that we don't want to share government. You know, that has been the song with some politicians. We don't want to share government. Our message is very clear. You need to lower the cost of living. And if you are going to lower the cost of living, it means the finance bill must be opened up. I know it's before the courts. I'm one of the lawyers in the court representing petitioner number 7. From the look of things, to me, the judiciary has been threatened, their personal security. And the moment your personal security is threatened, then it means the decisions you make from court, they are preconditioned because you are fearful of your own personal existence as a judge.
But where do you get that from?
Well, I've said the impression created so far.
It's an impression.
You can read the mood of a judge. You can read the demeanor of a judge. You can see a threatened judge.
No, you can't.
Whose
make
personal existence is threatened by the government, and therefore they must do everything to make the government happy.
So, what do you think about the determination yesterday by on the housing levy by the court?
Well,
you think also they were under impression, or the gesture would have given way to suggest that
the Law Society made a good case.
The government is overbearing on them?
The Law Society made a good case, but what I also picked from the judges, because the matters are proceeding mid next month, actually the judges are wishing that we could end the matter in a day, make all submissions, all preparations in a day, and I believe they will not take long before making a decision, such that although the government has gone to apply an act retrospectively, you are being fined we are going to be fined or taxed or levied on something which there was a stop by the court. They have decided to go back to the beginning of July. The question was, if you go back to July, then it means if somebody was paying salaries and it's a company, they did not deduct the 1.5% from the employer and the 1.5% from you. And it means the salaries of July were already paid. So where are you going to get another salary now to pay this act which is being applied backwards?
Let's hear from...
So I believe the courts will do their best. We have still a right of appeal. And even a right to go to Supreme Court.
Right.
What I know is once the Court of Appeal has determined as it has determined, and that's where the rain started beating Kenyans, then it means you cannot even appeal under 52B. You can't go to Supreme Court on that particular matter. It means then Kenyans have to bear and wait what this constitutional court will say. And once the constitutional court says that there are no interim orders, then it makes a determination. It means an appeal will still lie. I don't see much hope as a lawyer from courts by reading the demeanor of the judges and the mood of the judges and the mood of the country. The hope of Kenyans is them to redeem themselves in the next election, and their voice to speak. Or their right to picket or demonstrate.
All right, let me just see.
Cannot be stopped.
Pick up also the thoughts of Danson Mungatana on this. Is it an exception on this, that the law can be applied retrogressively?
I think it's a matter of interpretation. And so I don't want to comment too much on that because the processes are following each other. There is a good solid argument which has been made that in between the time of the conservatory order to the time that the Court of Appeal removed that conservatory order, should the law apply, the taxation apply within that period? There's an argument that has been made there that it should have, because I was watching the proceedings from my house in Tana River, and I saw the lawyers making that argument. But you see, we have not had the counter argument. And I think if I was the lawyer for the government, I would make a counter argument on that one, and the counter argument would also be equally strong, because if an order, for example, for attachment of an asset is an illegal order, and the higher court sets aside that order, and it determines that order for attachment was illegal, should we then say for the period that order was in force, it was a good order, and yet the higher court has already ruled it's a wrong order? So I would want...
The attachment then won't take place.
No.
And if you had attached, you'll have to restore.
Yes. So the question then is, between that time and the time that the higher court makes the order, was it a proper order? So this is a matter of decision that the court has to determine. And let's wait. He knows and I know that when you listen to the person prosecuting a case, you would believe that he is the most correct thing until you hear the other person who is opposing that position.
So when you talk about order, is it in the process propriety, or what do you mean by the order? Was it proper?
No, I'm saying...
In fact, I like the analogy of attachment.
No, let me
That's the best analogy.
Let me say that when you listen to their argument in brief, you would believe them until you listen to the argument on the other side. And then you will think that these guys were crazy. So let's hear then the judgment.
He makes a good case.
He makes a good case.
That's what I'm asking.
Also telling you,
if you
need to listen.
I really like the attachment.
You see, you need to listen. You need to listen to the counter argument, and it's a legal argument. Okay, once that argument is done and determined, then we have a decision. But for now, it's a matter of interpretation. But what he's saying makes sense to you. It makes sense to me. But what I'm also saying will make a lot of sense if I give you proper, well-researched argument. You will agree with me that if I'm giving an example of the attachment. If the attachment is wrong at the beginning, it was never supposed to have happened. But the lower court gave the orders. Then the higher court overturns those orders. Then they should go back to the initial place. You get?
So
the conservatory, let's go to the conservatory order. If the conservatory order was found out that it was wrong, just like an attachment, then it must go all the way back to the point where it was given. You need to understand that,
or it might cost on the merit of technicality.
So that's what I'm saying. You know, you are not a trained mind, and on the issues of law. And when you hear him and you hear me, you may not appreciate. So we'll need to get another trained mind called a judge to make that decision for us. So it will not be useful to the audience.
But even if I'm not a trained man, at least I can also make my own judgments as a layman.
The problem with a layman's judgment is that it is not a trained judgment. Doesn't fly. For example, now, if you found someone has shot someone, immediately the layman will say he has committed murder. But murder is not murder until you have intention. And you have the act.
It's been premeditated as well.
You must have the actus reus and the mens rea.
Yeah.
So for you to say that is murder and that guy should be convicted, you know, the untrained mind thinks differently from the trained mind. That's why the lawyer will go to court and say, we plead not guilty. You know, and yet you saw the guy shoot. So it's probably not the correct forum to go into law. You will get lost.
We'll get lost into it. No, but I just wanted to get the clarity on it so far. I know it's a matter, and we're not getting into the merits and demerits of it since we have the sub judice. But the question is, that is what I wanted to latch on, that yes, it's been done and dusted. As a company, I've paid off my obligations to my staff. and then we have this particular order that is coming. So do we go back retrospectively? I think I used the wrong term, retrospectively.
Now, I don't want to go into the rigmarole of law because I am not
You're not a trained mind.
I'm not a trained mind.
Yeah, so our learned friends will always be rubbing it on us.
I would allow them to have their way and their say on this matter. But I would like to say a few things that Honorable Senator, my friend, has said. On the issue of ICC and Karim Khan, I think we must speak on this, that what Azimio is doing is not fair for this country. Karim Khan's visit here was on a private capacity as a person who's been nominated to receive an honorary degree from Mount Kenya, which is okay for any individual in the world. That does not mean that when he comes here, he comes in his capacity as a prosecutor. He comes as an individual capacity coming to receive the award. And I think for you to serve at the ICC, you must have been seen to have a moral base that is above ground. Therefore, Karim Khan is properly in his place as the ICC. But I also want to say this, which has gone. I had one of, I think it was Martha Karua or one of the people in Azimio talk about genocide in this country. That was the most unfortunate statement that I have ever had. That people wish that this country has had genocide, that they can go on public national TV and talk about, we have had cases of genocide in this country. I don't know whether these people live in which country or which world, because the genocide we have seen in Rwanda and Burundi and other countries is something that you do not wish on your country. Even imagine that a country like Kenya would go into that kind of a path of genocide. It was a very unfortunate statement which must be condemned by all Kenyans, that there are leaders here who wish that this country goes to the dogs, that people are killed en masse, such that they can make a case at ICC to bring down a government. That was unfortunate, and we must call those people out for doing that. Secondly, the threshold for cases at ICC. My friend is a lawyer here. I don't know whether he stopped being a lawyer because he needs to advise his clients. He needs to advise Azimio. When you're talking about referring the Kenyan case
to the ICC,
what is the threshold for a case to be referred to the ICC? Mass murder? Has mass murder taken place
as a genocide?
In this country? Yes. Has mass murder?
38 people. 38
people
is mass murder.
No, let him finish.
This evacuation of population, it's called evacuation of populations or what, something like that. The thresholds and the people who have been prosecuted at ICC, the threshold is so high such that a country's judicial system cannot handle. And that's why ICC is invited. Has this country really gone to that level where we are saying the Kenyan case at the ICC, that they are saying Karim Khan should recuse himself because there's a Kenyan case? Which case? Which case are they talking about? These demonstrations that happened here, the Kenyan judicial system and the Kenyan system here is able to handle these cases. I'm not demeaning the fact that one Kenyan or 38, whatever the number, died. But I'm saying this country needs to earn international respect. You cannot destroy the international respect of your country. You cannot wish evil on your country and think that you're a patriot, that we should sing praise songs for you, while at the same time you are actually destroying.
But I need to butt in, because this is where I think we have Dan Mazo talking about the demeanor.
Yes.
Talking about the gesture.
Yes.
Because at the end of the day, we find there is a history when it comes to Karim Khan and President William Ruto, who is packed on the ICC.
Correct.
And the fact that also he's in the country, people will wonder, why is it very providential for him to be in the country when, even if it's now for that particular graduation honorary doctorate that he's getting as well. People will wonder, this time we have very fresh issues regarding ICC that has been fronted with the Azimio. We cannot really uncouple. They normally say politics all about optics.
Yes, but you see, Dibal, what you need to look at before you even talk about the demeanor of a judge and his posturing and the way he looks at things. One, you need to look at whether whatever you are talking about merits the attention of that court, merits the attention of that case or of that prosecutor. Before you start talking, do we have a case that meets the threshold of ICC now, such that now we can look at the demeanor of Karim Khan, or we can look at how he postures, we can look at his friendships.
Maybe we should before you come in, because Dan Mazo, you were the one who was fronting this genocide talk.
Yes.
And from your assessment, it's a misnomer, because also, is it a misnomer, I should ask, not really state, is it a misnomer that you use genocide in this particular context? Has it met the threshold? Should you have fronted this to the ICC? Did you use all the legal instruments that we have around here in the country and Africa, going to the East African Courts of Justice as well? You have also the Africa Court of Appeal as well. Did you exhaust all the avenues that you had?
Yes, I want to. You know, one of the roles of a president is to unite the nation, as required by the Constitution. So the moment you form government, even when you have opposition, it should be that you are embracing every Kenyan to feel that they belong to that country. But unfortunately, this is what has happened. We have split the country between Kenya Kwanza and Azimio in the judicial system, so that you have Kenya Kwanza minded judges who are there have to fight for Kenya Kwanza.
No. I think these are ridiculous. This is a ridiculous statement.
Wait.
You can't allow this on air. Mheshimiwa, you
I'll
can't
give you time to rebut.
Yes,
can you just finish his train?
Without evidence, how do you do that?
I'll get to the police also.
No.
You have people in the police.
Just hold on.
We are degenerating now. We are degenerating. You cannot do that. You cannot say that. You cannot say that on national TV. Judges, you are an advocate of the High Court. You cannot blame a judge that he is Kenya Kwanza or is Azimio just because he's ruling for you or against you. You are in that court and you know if you don't agree with a judge, you believe that he's biased against you. There's a proper application to file.
Yes.
You have not brought that application, and you are here telling the country that the demeanor of the judges.
Can he just finish his
own? He's doing the wrong thing.
He's got a right to his own opinion.
But
as well.
he is in that court. He's in that court. If he believes,
all courts generally.
Don't talk like that. Court. You have made that statement this morning to say that the demeanor of the judges seems they have been threatened personal security. Yes. I've challenged you to table that evidence. You don't have it, and you are in that court. If you believe that judge has been threatened and is ruling against you, why don't you bring the appropriate application before the judge?
All right, so you want to respond
to make those kind of ridiculous statements in public.
All right,
that's wrong.
You know, I'm aware of what has happened in previous matters.
No, it cannot be the basis for judging. This is a very important.
Could we also give
General is there?
Can he just get his award in age-wise as well?
The National Assembly is represented. The Senate is represented. All the important government ministers are there. You can't make a statement like that against.
All right, just give him space to actually also advance his own. If he's got any confirmable facts on what is being raised, you can actually.
And the role of judiciary is very crucial. And it is the judiciary finally which will hold things together, because currently, as things may, whether you like it or not, Parliament right now is a rubber stamp of the executive.
I'll come to that.
Then, judiciary has been weakened in terms of threats or in terms of people who hold.
Where's the evidence?
Who hold political position. Even a judge voted.
Where's the evidence?
Although the independence of a judge cannot be taken away.
Where's the evidence?
A judge voted. Did he not vote?
You know, these statements are the ones that weaken institutions. When you stand up here and say this judge is compromised, this judge is threatened, those are the statements that weaken that institution. When that judgment comes out, whether it's for you or against you, the people who are watching, the Kenyans who are watching, will say that institution is useless. This is how we kill institutions. We can't sit in a public place to say police are bad, police are bad. The president is, we don't accept the president. Parliament is rubber stamp. I think those statements.
Recent arrests of, I give a good example of Babu Owino. The Constitution requires you to be presented within 24 hours. You are arrested. 2 days go. The moment you appear in court for the first time, the court doesn't release you. And I really want to thank the courts which released some of us on anticipatory bail. That was really impressive. And then you are still detained further. Even when 24 hours are over and you have a right to bail, and that doesn't happen. and you are still detained further. So with those sort of recent arrests, and there were threatened to be many, and the threats which politicians have issued, you know, you have seen the talk of Ishungwa. I said on this television that what the talks of Ishungwa and some of the meetings held by the Kenya Kwanza members of parliament actually resulted into preparation of genocide. The statements made there were statements which are likely to cause genocide in the country or preparation
first of all, when you are talking about Mheshimiwa Babu Owino being detained and whatever, he has lawyers. There were applications made before the court for his bail release. There were also applications made by the prosecutor to say that they are carrying out further investigations. And for the court, the court also reserves the right to say, I will make a ruling tomorrow, I'll make a ruling the day after tomorrow. You cannot all that, blame it all on the prosecution or on the government. Trying to create a story out of that.
To be held more than 24 hours?
I agree.
3 days?
I agree.
Really? Are you saying that's a new justice system in the country?
But
that's a violation of the Constitution.
It's a violation of the Constitution, it's a violation of human rights law, it's a violation of international law.
You are probably right.
To shoot people who are not armed with a gun, really? And you
can go to court and be denied bail. You can go to court and you are told your ruling will be next week. You can go to court and find that the prosecution has made an argument to say you are interfering with witnesses, you are more likely to run away from the jurisdiction of this court, and so on. So there are reasons. Before you can make an argument to say that the courts are not following human rights and whatnot, there are procedures.
Okay. Let me just
this blanket condemnation kills institutions. Like if we came here and kept on saying KTN is biased, the people who are listening outside there will believe so. If we came here and say the country is going to the dogs, people will start believing so. And if you say here police are bad, the judges are bad, the parliament is bad, so who's going to hold the country together? No, I think as leaders, we need to have responsible discussions on the table.
All right. Okay. Let's rule out now the matter of court. We come to Parliament, because this is not the first time this allegation of Parliament being under the rubric, and rubber stamp of the executive is being raised, and we've seen attempts and people moving on and being lured on the other side to try and bolster the number of Kenya Kwanza side in the House. Maybe it's a high time that you can clarify, if at all, the Kenya Kwanza administration is not trying, or UDA is not trying to make sure it is a supermajority sort of a party in the National Assembly.
I want to tell you this.
The opposition is being compromised, and the president is actually particularly intent to making sure that he's decimating the opposition by getting their numbers, scooping from their numbers.
One, I want to say this, it is very democratic, and part of the tenets of democracy for you to always want to win numbers on your side. And that's the basic principle of politics. As a politician and as a political party, I would like Dan Manzo to join us. How I convince him is my problem, but I want to bolster my numbers all the time. And that is the basis of politics. Today, even Azimio would want to have members from our side cross to their side. And that's why you have an aisle. And that aisle gives you, in Parliament, you have an aisle that gives the opportunity for someone to cross the floor. In Kenyan terms, if you cross the floor, you're supposed to go for election. But it also provides that I can change his mind and make him vote with me. We had one of our members, gallant soldier Gadoni Wabushomba, voted with Azimio. We had this guy of Kabuchai, what is his name? Kalasinga, Majimbo Kalasinga. He's a Kenya Kwanza guy. He voted with Azimio. You know, we have at least 4 people who voted with Azimio in the finance bill. We never came out to say that they are compromised, or that it is normal in Parliament that when you sit there, you put strong arguments, convince each other, and that's why we have debate. Debates are meant to convince people. So if we can convince 10 members of Azimio, to come and vote with us. You don't blame it on the president and say that the president is compromising members of parliament, or to say that members of parliament, I tell you on this show, if you are a member of parliament who can be compromised by through money or through other incentives, you should not even be in parliament. You are a weak person. Your conscience should not allow you to do things like that. What we do in Kenya Kwanza is to try as much as possible to hold on our numbers and to increase those numbers through good arguments, through good policies. And when we have someone like Esther Pasaris vote with us, because she believes that we need a housing project in Nairobi, and we have convinced us that our manifesto is good and that we are taking this country forward, we welcome her. When we convince those members from Azimio, today I want to convince more members to come to us. Why? Because we want to pass law which we think is good. They need to give us a counter argument to show that our argument is bad, so that even me, Owen Baya, I'm waiting for Pio and I to make such a bold statement, such a strong statement, to convince me to want to vote with them. And that is the nature of Kenyan politics. But this idea that my friends always run to say, you know, Parliament has become a rubber stamp of the executive, it is not true. Parliament is independent. I sit in that Parliament. And I have sat with my friend Senator here, and we were in the same same party, same coalition with him. And there are arguments which we would sit with him, used to my friend, sit with him when we in Parliament and say, of course, this is a good argument. But because there is a party position, I will stick to my party position. But I tell him, no, I'll look at the good argument and go with the good argument, you know. So I want to say on this show that Parliament is not a rubber stamp of the executive. Parliament is independent, and decisions that are made by parliamentarians, and I respect parliamentarians, and I do not think that there is any member of Parliament who is so weak in such a way that he would receive 20,000 to vote for a bill or against a bill, or he will receive 100,000 to vote for a bill or against. I respect members of Parliament. Their integrity is above board, and we welcome good arguments. Secondly, Dibal, if you allow me, I want to say this. There has always been this talk about which my friend likes pushing Article 37. You know, he is one of the, probably his county members need to rename, give him a new name, call him Article 37 instead of Dan Mans, because he's always talking about Article 37. But I want to say this to demystify this 37. You know, Article 37 doesn't give absolute rights. It's not an absolute article, because it is the items that are talked in there, protest, demonstrations, but it gives a bat, peaceable and unarmed. It means that these rights that are within, the fundamental rights that are within Article 37 are not absolute. I'm not a lawyer, but I would make this argument. They're not absolute in such a way that you do not enjoy them without responsibility. When you must demonstrate, you must have certain levels of responsibility to it. One of them is you must be peaceable, and secondly, you must be unarmed. Now, if that is happening, the question is who determines who is unarmed and peaceable? Who determines that? You know, demonstration, we know what demonstration is. But before you go there, the police are supposed to protect property. They're supposed to protect lives. They take the two items that are in that bracket, peaceable and unarmed. So why do the police come? To ensure your demonstration is peaceable, to ensure your demonstrators are unarmed. What is the role of the organizer of a demonstration? What responsibility does he have? And that is where these guys want to abuse the Constitution, because that is what I say. It's an abuse of Article 37, because they want to think that Article 37 gives them absolute right to want to do anything the way they want. It comes with responsibility. Dan Mazo, when he goes to Kambani, I think there was a very peaceful demonstration that was led by Kalonzo Musyoka.
In Machakos.
In Machakos.
And the police were chided.
And I want to make it very clear. I watched that demonstration. It was peaceful. Why? Because Kalonzo Musyoka himself was there. And he ensured there was peace. He ensured demonstrators were unarmed. And you see that and say, yes, this is what we need to do when we want to apply Article 37. But you call for a demonstration in Nairobi. The first thing, my friend Sifuna will tell my former Secretary General Sifuna will tell his people, ensure you have assembled enough stones, ensure you have enough tires to burn.
No.
Ensure
we cannot verify that.
I want to put
to defend himself. That's a reductive of you to say.
I want to put it back.
Yes. Withdraw.
This show, I withdraw that statement.
Yes, please. Yes.
But I want to say this. So these guys, they watch. I cannot go to a demonstration if I see the first thing those people have are stones. They have lying stones on the road. They're burning tires. Then I'm saying, I want to go and lead that demonstration because I've called that demonstration. I want to tell Azimio, this article is open for you to use, not to abuse. Article 37 should be used properly, not to be abused, because an abuse of Article 37 by Azimio is actually an abuse of the Constitution, and they cannot be high priests of constitutionalism in this country if they continue to abuse the Constitution in this country. So I want to put them on notice that every time they want to abuse the Constitution and Article 37, the police will be there to ensure that they do not abuse the Constitution.
Dan Mazo, from your own estimation as well, and using your hunch, do you think these particular talks this time forth are going to fly?
I don't think so. The attitude of the government is, as you have seen from the speeches of Honorable Ishungo, is predetermined. And there's no way you will go to discussion with a predetermined mind.
And you're picking Honorable Ishungo because he's the lead person
from there. And he's
yes.
also the leader of majority in the House, and he's the one who's been making statements, sometimes which are very careless and are inflammatory, or they are not to bring the nation together. You see, if anybody purports to be representing the president, and the requirement of the president in the Constitution is to do as much as possible to bring the nation together, so that despite divergent views, you have a working nation, and you have a nation whereby people feel respected and feel that their rights are respected. I really want to say that peaceful demonstrations can be there, and they happened in Machakos that day. But I'll tell you, the police were asked by certain politicians from Kenya Kwanza, why did you allow Honorable Kalonzo Musyoka to have peaceful demonstrations in Machakos? You should have disrupted the crowds. And I think the police in Machakos did what should be done in the country. The moment policemen aligned, and you know this is the truth, or have the mind of we are protecting our Kenya Kwanza government. You know, police are supposed to be independent and neutral. It is certain individuals known in the police from certain tribes who have been attacking individuals known to be on a certain tribe. And that's a threshold of genocide. It should not be by political thinking. Or
but has this been documented? Anywhere? It will be good also for you to come on this table and actually table this evidentiary documents that this is these police that are lining up are aligned from, or they're coming from this particular tribe, and that's why they're attacking this particular tribe. Because I think also when we try and drive a wedge within the police force on tribal basis,
I'm not driving a wedge, but
our sentiments
unfortunately that's the situation, and that has happened in Kisumu. The good thing is the social media era, and we need to get certificates for these, products and pieces of evidence. The social media era is very good. Everything is on tape, everything is on photograph, everything is on picture. And that's a good thing about it. And there's overwhelming evidence. And that's why I'm saying each single case of manslaughter or murder in these demonstrations. Because if I'm, for example, if I'm carrying a stone and you have a gun, that does not justify you to kill me. And again, before those stones are picked, a tear gas starts. What happens is that there is a law, a colonial law called Public Order Act. And although it has not been amended and is in use in most Commonwealth
there's an attempt to amend it.
There's an attempt to amend it, but in the wrong way. All we need are regulations under Public Order Act, because there's a penal code, Public Order Act, and regulations. The regulations which were made in the year 2000 by former Attorney General Amos Wako, Senator, have now ended up, expiring. So once they expired, the new Minister of Interior, my good friend Honorable Kindiki, is supposed to make new regulations. These regulations say, and the practice all over the world is, the moment that demonstration begins becoming unpeaceful, by or acquires a new nature, then a police officer in the level of inspector gives a declaration and loud and clear announces and says this is over, you are given 15 minutes to clear. After those 15 minutes, then whatever happens to you belongs to you. But that doesn't happen in Kenya. You have a peaceful demonstration. The routing is supposed to be agreed upon. You are told don't use these routes. And what you saw in Serena in the first demonstration, instead of having a proclamation, the proclamation is in form of a tear gas. That's already bad faith, already shown from the side of government.
Allow me just to put tails. Allow me just to put tails on what you're saying. You just say that a police who's holding a gun and a demonstrator who's having a stone, a police is not warranted to shoot this particular demonstrator. From the constitution that it's been quoted, Article 37, it says every person has a right peaceably and unarmed to assemble, to demonstrate, to picket, and to present petitions to the public authorities. Would you say that the unarmed bit that has not been quite expressively,
you should not be armed at all.
Expressly actually elucidated from the constitution what arming is? Will you consider a stone an arm? Well,
let me take you back to one scenario.
Because a stone can kill.
You saw the stones throwing and some of your...
No, I just wanted to establish, you saw a stone can kill. You agree, isn't it?
Yes.
Goliath went down because of a stone.
We saw a catapult being used in Kisumu.
That's what I'm asking. So when you say
I
a stone and cannot be,
the demonstrators should be unarmed. But what causes this harming is when now the police come with guns and use more force.
So do you consider from your assessment that a stone is arming yourself?
They should be unarmed. A stone should not be used. Okay. But what causes the stone to be used?
A demonstrator should not carry a stone.
Yes, a demonstrator should not be armed at all. But when demonstrators are not armed, they should not be tear gas or shot dead at the same time. And that's why you saw there was one case, documented case, of a young man who was saying, you have tear gas my child is unable to breathe, and he was trying to, to mediate, with the police. Of course, somebody else used abusive language, and a police officer, from the back, picked this man, put him to the main police, and one fellow was seen twisting and breaking his hand completely. And this particular demonstrator has never been seen to date, and his family is unable to trace him. But he left in the hands of police and has never been seen to date. We are saying actions like these are really not fair. And where people have not been seen and you go to court and apply for habeas corpus, produce this particular person. Or where you approach the court, where the constitution says every offense in this country is releasable by bond, including murder, unless there are compelling reasons for you not to be released on bond.
I want to just butt in and say this. In Kisumu, there is this guy, he's called the Towel Man. He comes for the demonstrations with his son. I don't know whether you've seen, he wraps himself with a towel and holds the hands of his son with a placard. I don't know whether you've seen that guy, he's called Towel Man. And every time there's a demonstration, he comes out. He has no arm, he has no stones, he has nothing. He only comes, he has a towel wrapped around himself and his son, and holds his hand, the son of his hand, and they demonstrate. In that demonstration, and they come out and they say hi to the police, and they're carrying a placard, and they have a message on the placard, and they demonstrate and they finish and they go home. I think I've seen three times. How come the police have never even thrown tear gas on that man? Because he's peaceable, he's unarmed. He knows what Article 37 is about. So he comes out to demonstrate that way, and nothing happens to him. And the police just say, thank you, and he leaves. Why is it that, especially in Nairobi, I cannot tell the youth to do the same? Why is it that every time, and I had the Honorable Raila Odinga, for whom I have a lot of respect for, congratulate the young people for forcibly entering the CBD. I don't know whether you remember that day. I think it is the day when I was we were in Congo with the president, and I think that day it was not on the Sabasaba day. I think the day after, the next Wednesday, and every time demonstrators come out, they want to forcibly enter the CBD. Entering the CBD...
No, I need to butt in as well, because you're giving the wrong impression.
Yes.
That they entered forcibly in the CBD, and he was congratulating them. I think...
No, I don't think that happened.
That is not the scenario.
You are fully
out that clip.
No, that clip what you say.
Vijana mmefanya vizuri sana leo tumeingia CBD.
But it was not possible, because even Raila, he was sort of incommunicado, and he appeared on CBD, and then the gathering of the young guys who are in town, they flocked around him.
No, that was an accident. That was an accident. That day when he went out to have his shoe polished and all that.
Yeah. So you're not really talking about that.
I'm not talking about that day. There's another day
just to get clarity.
Congratulated the young people for forcibly entering.
Okay, I don't want to.
When you enter CBD, Dibal.
I don't want us to get splitting on the demonstrations. We've been there. I think you have a report with the Kenyan National Human Rights Commission.
Yes.
Let's see how that really pans out. Amnesty International as well. They've lodged a case also with the ICC. So let's not spend so much time on the demonstrations. Key issues that we want to put on the table.
Yes.
There is the IBC selection panel that is in place right now. And I think that also is a academic issue that will be discussed. And people have been saying, why are they still in office under the gazettement? And they're doing nothing, because as it is right now, the recruitment, the interviews have stalled, and billions of shillings are being paid to this this selection panel. What is the crisis at the moment that it should be given the much premium? Is it now the Finance Act, the cost of living, or even now the IBC selection panel, because we have also pending cases of by-elections, which will it throw us into a constitutional crisis?
Maybe let me say
in terms
something.
of those constituencies?
Let me say something. In Tana River County, we lost the member of the county assembly for Chewani Ward, and he was in fact the chair of the finance committee. We have been waiting for that ward to be filled through a by-election. And you see...
As the time lapsed?
The practical thing...
As the time lapsed since the Speaker of the County Assembly...
Let me make my point. The practical thing that is happening, their recruitment at the County Assembly Board, there is issuing of checks for bursaries that are stopped. There's lobbying for roads and projects in that particular county, in that particular ward, that has practically been disadvantaged, has disadvantaged the people of Chewani Ward. There was this MP who was killed here through a motorcycle accident. And then there is the most likely the pending by-election in Magarini constituency. What we are saying is that you have asked a question. There's a panel, The selection panel is not the actual IEBC. The selection panel is supposed to start the process for getting the IEBC commissioners. But then the opposition has raised issues. Now, I'm having a problem with the fact that nothing is moving on, but people in my ward are being disadvantaged, So my own take is that this is a matter of priority, and it is something that is singled out, that can be isolated from all the other politics, agreed upon and resolved. Issues around cost of living, they have so many, they are multifaceted. You cannot resolve that same issue with one issue standing. Like, let us have the selection panel done so that we can have these by-elections done. So for me, I'm thinking that we should focus on results on those issues that can be done without a problem. The other issues which are political, they should not be lumped with this one. That's my take.
But they should not be lumped, but it is right now, because they have raised hesitation with Kenya Kwanza regarding this particular selection panel. And if they have scruples with that, why would Kenya Kwanza drop it and start afresh with the negotiations, so that also they don't get spending money and nothing is really not coming out of it? in an age when, or in a time when you're talking about expenses and expenditure and the high cost of living.
So because they are gazetted,
it can be degazetted. It doesn't mean that that is the law of the means and the passions, that it cannot be
agreed,
revoked. Yes.
But you see, there's a law there that was followed. There's a law. It's not just a gazette notice that you just degazette. There's a law that was followed up to where it is now. So legally, they are in office unless that law is revoked. From where I sit, I think.
So which law are we talking about?
The law
just
that
educate me, because
no, it's not in the constitution.
It's
a statute that says how, because it was amended. It was an amendment on the
IBC Act.
It's the IBC Act.
Yes. The IBC Act. There was an amendment there that says you don't. First of all, they removed the power from the president to appoint, so it had to be now a selection panel. Now that selection panel, there's a process within Senate and National Assembly so that the names are published and agreed. And then that selection panel now is supposed now to interview the potential commissioners, shortlist them and agree, then take them to the president for appointment. So it's a process. You can't just remove them because they are within a certain law. They were not just brought up by the Gazette notice.
I understand.
They are following the statute.
But now, since it is dysfunctional, what do we do?
It will say something on that, if you allow me.
Please.
One of the things that, well, I think this question has been asked several times, but I think the truth is, this is a selection panel. They are not employees of government or that they're drawing a salary. They are only paid allowances as and when they sit. And when they call for a meeting, they are paid allowances at that level. Now that they do not have any work going on, no allowances or money is spent on them. Actually, this committee is hosted by Parliament. If you read the law, actually it's Parliament that hosts the selection panel in terms of secretariat, in terms of allowances, in terms of all those things. It is, if you read the law, it is actually by Parliament. That's why the staff who supports the committee are staff of Parliament. So, and the staff of Parliament, when they go for these meetings to discuss, they're only paid, I don't even think the staff of Parliament are paid allowances on this, probably per diem, so they go out of town and all that. But they are just staff of Parliament who has been picked to go give support to the committee. Now that committee only earns as and when they sit, and therefore the issues of whether government is spending money on them or not, as is now, is not here, not there, because they are not salaried. That is one of the most important things that we need to do. Secondly, the selection panel.
All right, and secondly, can we hear that from the other side of a break? My music is up. I'm pinched for time. If you could hold on to that particular thought, then we circle back with that on the other side of a break. Don't go away, you're watching Siasa Fiesta. When you come back as well, I'll take you back still to